Hi, I'm Beverly Allen. I'm a Tacoma-based attorney. I've been practicing for 10 years, and I'm honored to partner with the Pierce County Law Library and the Community How-To video series to discuss how to represent yourself in different aspects of the law. This video will focus on contempt versus modification for your parenting plans. And to that end, I have prepared a slide. Okay, so the title of this video is Look Before You Leap, Contempt versus Modification in Parenting Plans. The reason why I selected that title is I feel that there is some confusion out there about what is enforceable versus contempt, or for contempt versus what is something that we need to look at, maybe a modification of your parenting plan. So that is what I'm discussing with you today. And just a caveat, this video does not create an attorney-client relationship. I also recommend that you make sure that you're getting the most updated and recent information. Laws and court rules do change. So for the latest statutes, you'll want to check ledge.wa.gov. And for the latest court forms, you'll go to courts.wa.gov/forms. So it's better to avoid problems at all, right? They say that an ounce of prevention is better than a pound of cure. And in order to do that, in order to avoid problems, you need to focus on drafting your parenting plan well. So first, download the parenting plan at courts.wa.gov/forms. And then I've got some drafting tips here. First is be precise with your language. It needs to be clear not just to you and to the other parent, but also to the court what needs to happen. Now, I have seen some parenting plans that are very complex, are very complicated. If that's the case, it may be helpful for you to do a table that shows what days each parent gets under your proposal, or possibly attach a sample calendar to help the court understand what it is that you're trying to do. Second tip is use section 4 if this is going to be a restricted plan. So what I mean by restricted plan is if either parent has a problem with drugs, alcohol, violence, or some other issue that is going to require that they have limited contact or supervised contact, then section 4 helps you address all of those issues. It also can substitute for section 8, which is where you get into the residential schedule. And in fact, most parts of the parenting plan you can just skip. If you go through section 4, if you use that, then you can skip sections 8 through 11. Pay careful attention to the following sections on the parenting plan. Dispute resolution, section 6. I'm going to talk about that a little bit later, but it's important for you to consider how you want to resolve disputes that come up with the other parent. You can usually agree on a mediator. You can go to a center for dispute resolution. Every county has one in Washington. Or you can do a counselor, someone that you both trust to help you resolve disputes. Pay attention also to the holiday section. You need to specify when a holiday begins and ends to make that clear to both the other parent and to the court in the event of a dispute. Pay attention to the conflict section. That's section 11. So the conflict section is important because named holidays in general should take priority over the break. That could mean that the other parent is required to return the children to you for a specific holiday, even though that might be part of their time. You can also specify that birthdays take priority, or you can have some other order of priority there. Transportation section. This is also important. Who is responsible for picking up the children or transporting the children? Are there limits on who can do the transportation? And then, of course, the other section, section 14. You are not required to put anything in this section, but if you have specific things such as you want a rule that there's no video games after 9 p.m., you can put that in the other section. Another common provision is that neither parent shall disparage or talk negatively about the other parent, and that would go in section 14. So section 14 is important for different parenting aspects that don't fall under the residential schedule. I've touched on dispute resolution. This is the actual language in there, and it just reiterates, parents may have disagreements about shared decisions or about what parts of the parenting plan mean. In order to solve disagreements without going to court, you need to specify how those disputes are going to be resolved. There are benefits to dispute resolution. It's less expensive than court. A professional can help you brainstorm solutions. You can also be creative with those solutions, and they can be conducted remotely with with video technology. So dispute resolution is great, and I highly recommend it. So you need to ask yourself, is it contempt when you're having a problem with the other parent, or is it some problem or ambiguity with the parenting plan itself? If so, you can resolve that problem or ambiguity by using the modification mechanism. So what is contempt? Contempt is a clear violation of a written court order. So it's not a violation of an oral comment that a court may have made as part of the ruling. You need to be able to point the court's attention to a specific order and language that the other parent violated. Also important, it has to be the version that's signed by a judge or a commissioner. It can't simply be a version that you drafted. It needs to be a court order. So contempt is not the failure of the other parent to make accommodations or agree on changes in time or rearranging visits. It's not the other parent having a bad attitude or even making parenting decisions that you disagree with. And it's not the other parent having different rules for the children. It's not even putting the child in danger, although that could be a police or a CPS issue. Here's what the court has had to say about contempt. In determining whether the findings of fact supports a conclusion of contempt, we strictly construe the order alleged to have been violated. The facts must constitute a plain violation of the orders. That's a Court of Appeals case, and that is what I mean by you have to be specific. It has to be clear. Okay, so you've decided it's not contempt, but it's a huge problem. Well, there's a couple of avenues that you can do. First, look to dispute resolution. Again, every county has a center for dispute resolution. In Pierce County, it's called the Center for Dialogue and Resolution. Private attorneys will also sometimes serve as mediators. A mediator is a neutral third party. They don't represent either of you, but they can help both of you with your parenting plan dispute. So whether or not that happens in mediation, the parents can always agree to changes on the parenting plan. These changes can be major or they can be minor. Again, section 14, the other section, is a good place to make the changes if the disagreement you're having is a general parenting one and not about the schedule per se. Also consider counseling. I have seen countless issues that have come up on parenting plans that can be resolved with counseling. This can either be co-parenting counseling, which is where the parents try to get on the same page, or parallel parenting, which is where the parents have different rules in each household, but neither household is interfering with the rules or the way that the other parent is conducting parenting. Also, children often have a hard time with divorce and can benefit from counseling for themselves as individuals. Okay, so if it is contempt, then you need to file an order to show cause, a notice of hearing, and a motion for contempt. All of these forms you get at courts.wa.gov. For right now, you can get a free link subscription while we're in this COVID-19 crisis. And there's another video about that on the Law Library website to help you do a links account subscription. Just a few brief tips about motion. So motion for contempt is you're asking the court a request. You need to follow the local rules, including page requirements and the time that you need to give the other parent notice. For contempt, you also have to personally serve it. There's another video that I've done about service of process, so make sure that you are personally serving it or that the other parent has accepted service of your motion. You will also need to support your motion for contempt with evidence. Evidence is really any documentation or statements that can help your case. In a contempt proceeding, unlike a DV or harassment proceeding, hearsay evidence would not be allowed. In other words, the person making the statement has to have personal knowledge of what they're testifying about. It can't simply be that they heard something. Evidence can also be text messages or emails or video or voicemails if transcribed. So you'll need to find a court-certified transcriptionist in order to be able to introduce that evidence into the court. If you are having a witness make a statement, they either need to do it on the declaration form at courts.wa.gov, or they at least need to sign the cover page of that declaration and then attach a written statement to that in order for that to be admissible. So again, the court is looking for statements from people who have specific knowledge. And if it's contempt, they have to have specific knowledge about the contempt. A statement that the other parent is just not doing their job well, that's not really going to help the court. There are some resources available to you to find out more. You can find forms at courts.wa.gov/forms. You can find guides for how to do contempt with Washington Law Help. This is a great resource. It has checklists, it has materials as well. And then for legal help, you can either contact my office for our walk-in Wednesdays or volunteer days, or you can go to Tacoma Volunteer Legal Services or the CLEAR program or the Moderate Means program as well. These are all resources that help either low income or families of moderate means to be able to get assistance and do work. Right now during the COVID-19 crisis, I am not doing physical appointments for counseling for free for members of the community, but I am going through Tacoma Pro Bono program, and I am one of their volunteers. So they are a great program. They're helping people throughout this crisis. So the thought I'd like to leave you with is, it is always better for parents to resolve their dispute than to take that to the court. You have control over the process if you are the one driving it. So use dispute resolution in order to resolve your dispute with the other parent. And I hope everyone stays safe, and thank you for tuning in. My name is Beverly Allen, and it's been a pleasure partnering with the Pierce County Law Library.